From the introduction to the 1989 Cambridge edition of On Liberty, we have the following quote. His principle puts the burden of proof on those who propose to restrict the liberty of others. There is a good chance of Canada running into scapegoating problems in the future. Mill recognized there was and would be constant attempts by the legislative or the executive of direct interference with private conduct and control individuals in things in which they have not hitherto been accustomed to be controlled by it. Justice Stone said much the same thing when he wrote, "History teaches us that there have been but few infringements of personal liberty by the state which have not been justified in the name of public good, and few which have not been directed, as they are now, at politically helpless minorities." It has been a very expensive process to prove that we cannabis people are relatively harmless. It has cost this movement hundreds of thousands of dollars, and the scapegoats of tomorrow may not be in possession of such resources. We must heed the words of Judge Robert H. Jackson of the Nuremberg war trials, when he said, "What the world needs is not to turn one crowd out of the concentration camps and put another crowd in, but to end the concentration camp idea." To end the concentration camp idea, we need a process that requires a heavy burden of proof placed on the lawmakers of inherent harm to others, just as John Stuart Mill suggested. To be consistent with natural justice, to respect the principle of being presumed innocent until proven guilty found in Article 11 of the Universal Declaration of Human Rights and Section 11 of the Charter, the test should be you don't go to jail if the state cannot prove that your recently criminalized and heavily contested activities will cause significant harm to others. Rather than examine the concepts of inherent harm, mitigatable harm, and harm reduction, my honorable judges in their decisions have chosen only to talk about the direct or indirect harms, the serious or trivial harms, and the vulnerable groups of cannabis users. Does it not make sense to first determine whether the concerns around cannabis are inherent or mitigatable before we decide whether cannabis harms are trivial or significant? This is a key component of my argument, and a question I beg your honors not to ignore. It is argued by the Crown that if a challenge to possession laws fail, then it is not necessary to even look at the arguments against trafficking. In my submission, legal dealers can mitigate harms in a regulated market that are more difficult to mitigate in a black market. There is plenty of evidence that both harm reduction and cannabis harm reduction exist. In Stockdale versus Hansard, Lord Denman observed that no valid conclusion as to the use of a thing can be drawn from its abuse. In On Liberty, John Stuart Mill wrote, "The class of dealers in strong drinks, though interested in their abuse, are indispensably required for the sake of their legitimate use." Casanova once said, "In wise hands, poison is medicine, and in foolish hands, medicine is poison." This is true of cannabis as much as every other drug, except a little less, as cannabis is the only popular recreational drug with which one cannot take an overdose that will cause death. As for sources of cannabis harm reduction specifically, there are also many to choose from. The Chinese herbalist Li Shizhen explained that hallucinations and an unsteady gait come through immoderate use of cannabis. Arab doctors of the 12th century advised that eating cannabis helps against sorrow if you eat a little. More recently still, the 1997 World Health Organization report on cannabis pointed to dose as the first of a long list of factors involved in the effects of cannabis. The report noted The behavioral effects of cannabis can be influenced by the social context of use. Variability can be due to factors related to dose, mode of administration, physiological and pharmacological differences, complexity of performance tasks, situational demands during testing, and the prior drug experience of the subject. As mentioned before, Sergeant Dion testified in the Malmo-Levine trial that the Harm Reduction Club offered methods to reduce the harm from any marijuana use, and that the club was a consumer-oriented venture. At the end of the day of testimony in R versus Caine, the Crown's star witness, Dr. Callant, testified that impairment was primarily dose-related. In her decision in Caine, Her Honor Judge Howard wrote, "Naive users should be careful, and if they choose to smoke, should do so with experienced users and in an appropriate setting." Justice Braidwood quotes Justice Howard in Caine, where she pointed out that it is a prohibition of marijuana that creates an artificial lack of government control over the quality of the drug on the market. Highlighting the role of education in cannabis harm reduction, the 1991 judgment of the German Regional Court, hereforto called the Lübeck decision, stated, "In view of the relatively limited dangers cannabis products involve, a suitable program of education and information is sufficient to deal with them and is a less drastic measure." Justice Braidwood mentions the Umiet report and its recommendations that no conduct should be defined as criminal unless it represents a serious threat to society and unless the acts cannot be dealt with through other social or legal means. Justice Braidwood then quoted two other reports, the Law Reform Commission report and the Criminal Law in Canadian Society report, which say more or less the same thing. Justice Curtis accepted into evidence the following statements. "It is submitted that the harm caused by prohibition itself must be weighed in the balance against the lack of harm to 95% of the users, the mitigatable harm caused to the other 5%, and the insignificant harm their conduct causes to others or to society as a whole." And, also in evidence, there is, in fact, no harmful effects of marijuana on others or society that can't be reduced in some way through reasonable regulation, i.e. impairment testing. The harmful effects on the individual user are minor, mitigatable, and only affect less than 1% of the population who are chronic users in any event. These statements are the key to understanding the arguments presented by the Harm Reduction Club. My lawyer friends tell me these statements have been accepted into evidence, but they never make it into the decisions. The lack of responsiveness on the harm reduction argument in Canada by the lower courts seems similar to the situation in the US, where it is the medical necessity arguments that are not allowed to be raised. In my submission, it is an affront to natural justice to deny even responding to the chosen legal arguments of so many possible scapegoats. If we choose to look at cannabis use without understanding the difference between black market and proper use, we risk assessing cannabis harms incorrectly, basing our conclusions only on the effects of unregulated distribution and uneducated use. A more accurate description of the nature of cannabis law would be protection and encouragement of certain synthetic or more easily monopolizable drug industries, similar to the monopoly of the dairy industry challenged in the margarine reference case. Bouvier's Law Dictionary includes the prohibition of unfair monopolies within its definition of liberty. In the margarine reference case, the court found that business had to be protected from monopoly, or legislation that was for, quote, protecting those engaged in the dairy industry, legislation that was unrelated to public peace order, security, health, or morality. From the above two sources, it is submitted that there exists a legal basis for the cannabis growers and dealers to demand the liberty to compete with and replace the more dangerous drug industries. Not being able to afford decent food, housing, and medicine kills people. Canadians have the right to lift themselves out of poverty in any harmless manner, and there is a legal basis for that as well. In 1946, natural cannabis tinctures were removed from the shelves of pharmacies only 2 years after synthetic forms of cannabis were produced. To establish a margarine reference defense for cannabis dealers, it is not necessary to prove motive or intent or to nab the culprit. It's only necessary to demonstrate the law has the effect of a monopoly. In Article 25 of the United Nations Universal Declaration of Human Rights, it says that everyone has the right to a standard of living adequate for the health and well-being of himself and his family, including food, clothing, housing, and medical care, and necessary social services, and the right to security in the event of unemployment, sickness, disability, widowhood, old age, or other lack of livelihood in circumstances beyond his control. In Singh versus Minister of Employment and Immigration, the court said, "The right to security of the person means not only protection of one's physical integrity, but the provisions of necessaries for its support." In my submission, the war on cannabis is a war on the viable agricultural economy, in effect causing poverty by withdrawing wealth from a labor-intensive agricultural industry and concentrating it in the capital-intensive chemical industry. The war on cannabis keeps the poor people poor and under the policeman's boot. In my submission, if this society truly wants the hippies to get off welfare and get jobs, it should not prevent those hippies from getting jobs in the emerging herbal medicine economy. John Stuart Mill wrote that civilized society should guarantee the freedom to unite for any purpose not involving harm to others, the persons combining being supposed to be of full age and not forced or deceived. This could be easily said of the Harm Reduction Club and most cannabis dealers. In R versus Morgenthaler, Wilson J. wrote that the state will respect choices made by individuals and, to the greatest extent possible, will avoid subordinating these choices to any one conception of the good life. The experiment in Holland with the open sales of cannabis demonstrate what is possible. In my submission, the harm principle not only applies to Section 7, protecting individuals not proven harmful to others, but also Section 15, protecting groups not proven harmful to others. Section 15 states, "Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or physical or mental disability." Now, can it be said that a natural preference or orientation to herbs, a taste, over other more toxic synthetic stimulants, relaxants and antidepressants, result in the substance orientation of the individual being recognized as a personal characteristic not unlike an enumerated ground such as religion, philosophical orientation, or a recognized analogous ground found to exist in Vrend, which is sexual orientation. Given the relative harmlessness of substance orientation, why shouldn't this orientation receive the equal protection and the equal benefit of the law under Section 15 of the Charter? Similarly, why shouldn't a person wishing to choose a vocation, a pursuit, such as a cannabis farmer or breeder, or a cannabis cafe owner who wishes to compete on a fair playing field with other substances providers, such as cultivators and distributors of alcohol, tobacco, and coffee products, why shouldn't that person also receive Section 15 protection? The vocation orientation.